Hi guys! Welcome to another episode of Atty. Vlogger, Law for the Everyday Layman. Today we take up part 10 on the law of sales and we'll talk about the rights and remedies of the seller in case of breach of a contract of sale. Now if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Okay? Now, when we talk about the remedies of the seller, let's first begin with the remedies in case of a sale of immovable or real property. Okay? When it comes to immovable property, the first rule that we have to know is the doctrine of anticipatory breach, which is found in Article 1591 of the Civil Code. Under this doctrine, this contemplates a situation where the real property has already been delivered to the buyer, but the buyer has not yet paid the price. Okay? In this case, the seller may bring an action to rescind the contract, or he may ask for rescission of the contract in case he has reasonable grounds to fear the loss of the real property or of the price. In other words, the seller has reasonable grounds to fear that the buyer may unduly dissipate or destroy the property, or there is danger that the buyer may become or is already insolvent. Okay, again, if there is reasonable grounds in those cases, then we apply 1591. But if there are no reasonable grounds, then we just apply 1191 on rescission of obligations, in which case the requirement is that there must be a substantial breach. Okay, but again, if there are reasonable grounds, we apply 1591. 1591 will apply whether the sale is in straight payment or one-time payment, or if it's a sale on installments. Because the law does not distinguish, so neither should we distinguish. Okay? The next rule you need to know is under 1592. As a general rule, under 1191, in case of breach or non-payment by the buyer, then the seller is entitled to rescind or ask for rescission of the contract of sale. However, this right to rescind is subject, of course, to the special rules provided in 1592. 1592 allows the buyer to keep paying for the real property until there has been a demand for rescission made by the seller upon the buyer. In other words, if the seller keeps accepting the delayed payments, okay, after the breach or default by the buyer, then the seller is deemed to have waived his right to bring an action for rescission. Okay? So the seller will now have to wait until the buyer defaults again before he can bring an action for rescission. Okay? Now, you will have to take note that this rule on 1592 will only apply to an absolute sale. In other words, 1592 does not apply first to sale of real property on installment, because the governing law here is Republic Act 6552 or the Maceda Law. I've talked about the Maceda Law in another video. Please just watch that, okay? The 1592 will also not apply in case of contracts to sell or conditional sales, because the sale does not exist as of yet. Okay? Please take note of this, because if you are presented with a problem, no, or an exam question, you have to determine first what is the nature of the sale, if it is absolute or conditional, or if it's a contract to sell. And if so, do not apply 1592, because 1592 again does not apply to contracts to sell or conditional sales, or to sales covered by the Maceda Law, because they are in installment basis. Okay? So those are the rules for immovable or real property. Let's move on to the rules or the remedies in case of movable or personal property. We first take up Article 1593 of the Civil Code. Okay? The seller may bring an action for a rescission of the contract if after the expiration of the period of delivery, meaning that there is no delivery yet, the buyer did not appear to accept delivery, meaning he did not show up, no? Or even if he appeared to accept delivery but did not tender the price, then those are the two situations when the seller may ask for rescission as a matter of right. Okay? And why is the seller allowed to rescind in these cases? Because movable property or personal property is not capable of maintaining a stable price in the market. And every delay in the payment to the seller will necessarily result in prejudice to the seller. Okay? So that's why the seller is allowed to rescind in those two cases I mentioned. Okay? Now, when it comes to the sale of goods, the seller may bring an action for specific performance or an action for the price under Article 1595. Okay? And these are the three cases in which an action for the price is available. Okay? First, in case the ownership has passed to the buyer, but the buyer wrongfully neglects or refuses to pay. Second, in case the price is payable on a certain day and the buyer wrongfully neglects or refuses to pay the price on that day so stipulated, then the seller may bring an action for the price or specific performance. Take note that this second situation even contemplates a situation where there is no delivery yet, as long as there is a stipulated date for payment. Okay? However, also take note that the buyer may raise as a defense the fact that the seller manifested an inability to perform his obligation at any time before judgment of the case for specific performance. Okay, why? Because remember, sale is a reciprocal obligation. Once one party is cannot once a party is able to perform its obligation and the party does not, then there is already delay on the part of the other party. Okay? So that's the rationale for the second scenario. And finally, the third scenario is if goods cannot be readily resold for a reasonable price, even if the ownership has not yet passed, then the seller may offer to deliver the goods to the buyer. Okay? Now, if the buyer wrongfully refuses to receive the goods, take note of Article 1588, because 1588 says that the title to the goods passes to the buyer from the moment that they are placed at his disposal and he wrongfully refuses to receive them. He has to refuse the goods without just cause. Okay? So if the goods cannot be readily resold in that case and for a reasonable price, no, even if the ownership has not yet passed, then the seller can bring an action for the price. Of course, the seller must notify that the buyer that he holds the goods as a bailee for the buyer, and that he may treat the goods as already belonging to the buyer. Okay? Now, let's go to the next remedy. The seller can bring an action for damages in case of a sale of goods. There are also three scenarios contemplated here. First, when the buyer wrongfully neglects or refuses to accept delivery and to pay. Okay? Second, in case of executory contracts, no, where those which are not yet performed, no, where the ownership has not yet passed and the seller cannot bring an action for the price, no, since the remedy of action for the price is not available to the seller, let's not leave the seller without any remedy, no. So his remedy in that case that the action for the price is absent is instead to bring an action for damages. And the final scenario for an action for damages is, of course, if the goods are not yet identified at the time of the contract or subsequent thereto. Because remember, in a case of sale, the goods must either be determined or determinable, but they must be determinate at the time of delivery. Okay? Now, in such case, if they are not identified at the time of the contract or subsequent thereto, then the seller can bring an action for damages. Okay? And how do we measure the damages that will be due to the seller? Okay? The measure in general is the estimated loss which directly and naturally result from the breach. Okay? And the first scenario is in case there is a market available for the goods, no? Meaning there are other people who want to buy it. In such a case, then the measure of the damages will simply be the difference between the contract price and the market or current price at the time the goods should have been accepted, or if that time is not known, then at the time of refusal. Again, difference between contract price and the market or current price at that time the goods should have been accepted, or if that's not known, then at the time of refusal. Okay? The law also authorizes a higher amount of damages in case there are special circumstances. But of course, those special circumstances must be clearly and convincingly proved. Okay? Otherwise, then we just go to the default formula which I just discussed earlier. Okay? Now, the other scenario is in case the buyer repudiates the contract. Okay? If the buyer repudiates the contract, then the measure of damages shall be the cost of labor and materials prior to or before the notice of repudiation, plus the profit that would have been realized had the sale been fully performed. Okay? Now we can go on to the next remedy when it comes to sale of goods. We have technical rescission under 1597 of the Civil Code. Okay? Under technical rescission, the scenario contemplated here is that there is no delivery yet. Okay? In case there is no delivery yet, the seller may bring an action to rescind the contract if the buyer commits any of the following, no? If the buyer repudiates the contract, or if the buyer manifests an inability to perform his obligations, or if the buyer has committed a breach of the contract. In those cases, even if there is no delivery, the seller can bring an action for rescission. Okay? Take note, there is no delivery, because if there is delivery, we do not apply 1597 on technical rescission. Instead, if there is delivery, we apply 1595 for action for the price. Okay? So that's it for technical rescission. Let's now go to the remedies of an unpaid seller, no? Now, who is an unpaid seller? The law says that a person is deemed to be an unpaid seller if the whole price has not been paid or has not been tendered or offered. Okay? That's the first. Or second, a person is deemed to be an unpaid seller if a bill of exchange or other negotiable instrument has been given as a condition of payment. Okay? And the condition is broken because that instrument was either dishonored, or the buyer became insolvent, or any other analogous situation. Okay? Now, who will be considered as an unpaid seller, no? Of course, the person who is unpaid itself, no, himself, no? But this term unpaid seller also includes the agent of the unpaid seller. It will also include either a consignor or an agent who has actually paid the price or is responsible for the price, or third, any other person who is in the possession of a seller. Okay? Now, let's go quickly through the rights of an unpaid seller. There is the possessory lien, the right of stoppage intransitive, there is a special right of resale, a special right of rescission, the action for the price or specific performance, action for damages, the recto law, and the Maceda law. Okay? Now, let's first talk about the possessory lien. Okay? An unpaid seller has what is called a possessory lien. In other words, the seller who is in possession and control of the goods may retain that possession until he is paid, or at least a tender of payment is made to him. Okay? Necessarily, the possessory lien involves the possession and control of the seller. Because if he has lost possession and the goods are actually possessed by the buyer now, then the seller has lost his possessory lien. That is not to say that he has lost his other liens, because the seller may have a lien on the price, alright? But the possessory lien necessarily contemplates actual possession or control by the seller. Now, what if part of the goods has been delivered? Then the possessory lien will only exist as to the goods that still remain with the seller. The seller can still exercise his possessory lien over the goods that remain with him, except of course if there has been a waiver of that right. meaning that the seller has said that even if he delivers part, he is giving up his possessory lien. That is valid, okay? Otherwise, if there is no waiver, then the seller can still exercise his possessory lien over the remainder, okay? Now, let's go through the requisites of the possessory lien, okay? First, goods are... not the requisites, the instances when there is a possessory lien, okay? First, when goods are sold without a stipulation of credit, okay? Why? Because in the case of a stipulation regarding credit, the buyer is able to acquire the goods without having paid yet. Okay, payment is subject to a period depending on the credit arrangement. And the seller parts with the goods on the strength of the credit of the buyer. Okay, so there is no payment yet and the possession is already with the buyer. Okay, so there will be a possessory lien in case the goods are sold and there is no stipulation on credit. Okay, because if there is a stipulation on credit, then there is no possessory lien. Okay? Second case when there is a possessory lien. Now, there is stipulation on credit or goods are sold on credit, but the credit term has now expired. Okay? Meaning there is no payment yet at the due date. Okay? So, second case again, when goods are sold on credit but the credit term has expired. And third case, when there is a possessory lien, of course, if the buyer becomes insolvent. Okay? So, those are the three cases when there is a possessory lien. Now, I mentioned earlier that the possessory lien necessarily involves possession by the seller, okay? And the lien is lost when he parts with possession, okay? So, the cases where the possessory lien is lost is, of course, if there is delivery by the seller to the carrier or other bailey for the purposes of transmitting ownership to the buyer. This case is based on the rule that the general rule rather, that delivery to the carrier is also delivery to the buyer, unless of course the seller has reserved ownership to himself. Okay? Second case when the lien is lost is if the buyer or his agent lawfully acquires possession over the goods. When I say lawfully, it has to be a situation sanctioned or allowed by law. Because let's say it's the right to the buyer has possession of the goods because he's merely exercising his right to examine the goods, then that is not a lawful acquisition of possession. And in such case, the possessory lien is not yet lost, okay? Because it's only the right to examine. But if the buyer or his agent lawfully acquires possession over the goods, then the possessory lien is lost. And finally, the possessory lien of the seller is also lost in case he has waived his right to the possessory lien. Now, the waiver may be expressed, but it also may be implied, such as when the seller allows the buyer to make alterations or modifications to the goods. Because in such case, the seller is allowing the buyer to exercise acts of ownership. And in such case, it is as if the seller is giving up his possessory lien. Okay? Now, please remember that the seller does not lose his lien if he brings an action to recover the price. Even all the way until there is a judgment for the price. Okay? The possessory lien is not lost. This is actually explicitly provided for by law. Okay? So with that, we can now move on to the right of stoppage in transitu. Okay? In this case, the seller parts with the goods, by delivering the goods to the carrier or other bailey, but the unpaid seller may resume possession of the goods either by giving by actually taking the possession of the goods, actual taking of possession, or by giving notice to the carrier or other bailey that he has a claim over the goods and they should be now held on his behalf. Okay? Now, in order for the right of stoppage in transitu to apply, there are requisites. Okay? First, the seller, of course, must be unpaid. Second, the goods must actually be in transit. Third, the buyer must be insolvent. And fourth, the seller must actually take possession, or he must give notice of his claim to the carrier or other bailee. Okay? Now, I mentioned that the goods must be in transit. And how do we know if goods are in transit? Well, the law gives us the situations. Okay? First, in case the seller has made delivery of the goods to the carrier or the bailee before the buyer or his agent takes the delivery. Okay? Second, if the goods are rejected by the buyer and the carrier or bailee continues in possession even if the seller refuses to accept the return of the goods. Okay? Again, goods are in transit. They are in transit after they have been delivered to the carrier, whether by air, land, or sea. Okay? And right before the moment that the buyer actually takes possession of the goods. Okay? So that period, no? When it's given to the carrier and before the buyer gets the goods are in transit. So let's say this is the sea, the goods are in transit. Or the second scenario again is when the goods are rejected by the buyer, okay, and the carrier continues in possession as a bailee on behalf of the seller. Okay, the law also gives us the situations when goods are no longer in transit. Okay, and the first one is after delivery to the buyer at the point of destination. Okay, when goods are in transit or are to be transmitted through a carrier, then there is a point of departure and there is a point of destination or arrival. Okay, after delivery to the buyer at the point of destination, then goods are no longer in transit because they're already with the buyer, no? Okay, second, after arrival at destination, the carrier or other bailee acknowledges to the buyer that, hey, I'm holding this on your behalf. Okay, then goods are no longer in transit. Okay, and finally, goods are no longer in transit if it is the carrier or the other bailee who wrongfully refuses to deliver the goods to the buyer or his agent. Okay, if the carrier does not wrongfully refuses to give it to the buyer, then the goods are no longer in transit. Okay? Now, the rule on part delivery in possessory lien also applies here in stoppage and transit too. So, if part of the goods has been delivered to the buyer but there are remaining goods that are still in transit, then the seller has the right of stoppage and transit too over the remainder which has not yet been delivered. Okay? Except, of course, if there has been a waiver, meaning the seller said that even if there has part delivery and there's part that's still in transit, I will no longer exercise my right of stoppage and transit too. In that case, since there is a waiver, then that rule is no longer applicable. Otherwise, if there is no waiver, then the seller may exercise his right of stoppage and transit too over the part that has not yet been delivered. Okay? So now, let's say the seller exercises his right to stoppage in transit too. Okay, what are the effects? Okay, first, of course, the goods are no longer in transit. Okay, because he has already exercised his right of stoppage in transit too. Okay, second, the contract of carriage is now terminated. Okay, or extinguished, and now the carrier simply becomes a bailee. In other words, he holds the goods in favor or on behalf of the seller, and he will be now liable as such bailee to the seller. Okay, the third effect is that the consequence is that the carrier should not deliver the goods to the buyer anymore, because if the carrier delivers the goods to the buyer despite being stopped in transit too, then the carrier may be held liable for damages to the seller. Okay, now, this right of stoppage transit too will still remain even if the buyer has already sold the goods. Okay? Because remember, even if the buyer does not have possession of the goods yet, he can enter into a contract of sale, because the rule is the seller must only have a right to transfer delivery at the to transfer ownership at the time of delivery, if you remember, no, in our earlier discussions. Okay? So, in case the buyer has sold the goods which are still in transit, the right of stoppage in transit too is not lost. No, the seller can still exercise that right. Okay? So the only exceptions to that rule, that sale by the buyer does not affect the right of transitu, are as follows, no? If the seller assents or consents to the sale of the buyer, then the seller loses his right of stoppage in transitu. Okay? And second is if the goods are covered by a negotiable document of title, because if you remember our discussion, the negotiable documents of title, the negotiation of that document of title constitutes delivery over the goods, okay? As long as it is negotiated to a purchaser in good faith and for value, okay? Now, that's it for stoppage in transitu. Let's go to the special right of resale. Okay? This is very important that you take note that the special right of resale is only available if the seller has either the right of possessory lien or still has the right of stoppage in transitu or has even exercised it, no? Because if he doesn't have either of those two, then there is no special right of resale, okay? Now, the special right of resale can be exercised under any of the following circumstances, okay? First, of course, if the goods are perishable, okay? Time is of the essence in this case. The goods might perish, so the seller has a special right of resale. He can resell the goods. Second, if the right to resell is expressly granted through the contract, not through the stipulation in the contract, in case of default of the buyer. And finally, if the buyer delays payment unless there is for an unreasonable time, rather, no? In case the buyer does not make payment within a reasonable time, then the seller has special right to resell. Okay? Now, what is the nature of the sale? It can be either private or it can be a public sale. Now, the seller is not obligated to give notice of his intention to resell the goods or of the time of the place of the sale. The seller is not obligated to give notice of those things to the buyer. Okay, ha? It does not affect the validity of the resale. However, such giving or failure to give notice will be necessary to determine if indeed the buyer was in default for an unreasonable amount of time. Okay? Because remember, that's one of the cases to exercise the right of resale, no? That the buyer was in default for an unreasonable amount of time. And the sending of notice is to enable the court to know if the buyer indeed was in default for an unreasonable amount of time. Okay? Now, in case the seller is able to resell the goods to a new buyer, then this new buyer acquires a good title as against the original buyer. Okay? Siya na ang may-ari. Wala nang pakialam yung original buyer, because the seller has now sold it legally to the new buyer. Okay? And in case the seller was able to sell the goods for a price higher than originally agreed upon, then he is not even liable to give that profit to the original buyer. The original buyer cannot claim that. But if the seller sells it for a price lower than that agreed upon, then the seller may even sue for the balance and the damages if warranted. Okay? In other words, if there is a deficiency, he can ask the original buyer to pay him the deficiency. Okay? So, that's it for special right of resale. We'll go now to the special right to rescind. Okay? Now, the special right of rescind, similar to the right of resale, also requires that the seller still have either the possessory lien or the right of stoppage in transitu, or that he exercised already the right of stoppage in transitu. And the situations within which the special right to rescind are available are as follows. Okay, first, the right to rescind on default is expressly agreed upon or is expressly reserved, no? There is a stipulation in the contract allowing for rescission in case of default. And second is when the buyer is in default for an unreasonable amount of time. Okay? The effect here is that, of course, the seller resumes ownership over the goods as if he did not part with the goods. Okay? He is no longer liable to the buyer on the contract, but the buyer may be held liable for damages due to the breach which he caused. Okay? And the seller must claim rescission either by notice or by some overt act. Okay? It can't just happen magically or automatically. The seller still either must give notice or perform some overt act. But the sending of notice is not necessary. The sending of notice or the communication of the notice to the buyer is not necessary to say that in order for the rescission to be validly claimed. Okay? But the communication or the sending of the notice of rescission is only necessary to determine if the buyer was in default for an unreasonable amount of time. Okay? Otherwise, the rescission must simply be claimed by either sending notice or by performing an overt act. Okay? Okay, so now the action for the price is the next remedy, but we have already discussed that earlier, no? And then we also have the next remedy of an unpaid seller, or in general would be when it comes to personal properties on sale in installment, would be the recto law. Okay? And the recto law is simply Article 1484 of the Civil Code. I've discussed this in depth in another video, so please just watch that. Just remember that in case of the recto law of a sale of personal property in installments, just remember that the remedies here given to the seller, namely specific performance, rescission, or foreclosure of the chattel mortgage, these remedies are alternative, meaning just pick one. Okay? Of course, subject to the exception in 1191 that where specific performance is no longer available, rescission may still be availed of. Okay? But as a general rule, these are alternative. And in case the seller picks foreclosure, he can no longer claim the balance or deficiency if the thing was sold at the public auction for less than what is still due him. Okay? Just watch my video for a deeper discussion. Okay, and finally, remedies of the seller, we have the Maceda law, no? And under the Maceda law, I also have a video on this. Please just watch it for a deeper discussion. But in general, the seller may rescind or cancel the contract in case only if he sends a notice of cancellation or demand for rescission by notarial act. Okay, it has to be notarized, no? If he can only send that demand for rescission after he respects the grace period which is given by the law to the buyer. Okay, so there's a grace period. The seller should wait for that to lapse. Then he can send the notice of cancellation or demand for rescission by notarial act. Okay, so that's it for the remedies of the seller in case of breach of contract of sale. Okay, so I hope you may have picked up a thing or two, and I hope to see you for my next video. Okay, see you soon. Bye.